Afternoon to those of you who are joining us for today's webinar, Legal Business Entity Formation 101 with Alan Singleton of Singleton Law Firm here in Champaign. Just a few quick things before I hand it over to Alan. You are welcome to ask questions. We just ask that you submit those via the chat box that can be found in your Zoom toolbar, and we will address those throughout the session and be sure to answer any of them before we wrap up today's webinar. You're also going to get a follow-up email that will go out tomorrow morning, and it will include the recording of today's session. So if you missed anything, want to go back and listen to Alan speak on a topic again or anything like that, you will have access to do that. So again, just drop anything in that chat and we will make sure it gets addressed. But I will go ahead and hand it over to Alan and we can get started.
Thank you, Jordan. I appreciate the opportunity to visit today. What I'll do today is sort of try to give you an overview of a number of issues to think about. Keep in mind that you shouldn't take any of this as specific legal advice because each situation can be a little bit different. You could have an individual who's not a citizen of this country. You could have a situation where your enterprise has something unique, such as a special licensure, some sort of accreditation that's needed. So there are all sorts of caveats that could apply on top of this general overview. I always encourage you to seek the advice of an accountant and an attorney to help set up your business in a good fashion. Think of establishing your business entity as building a foundation, a legal foundation for your business. If you're going to build a small fort in the yard and you're a kid, it may be okay to be informal and just start putting the boards together and have fun with it. If you're going to build a mansion or hopefully build a mansion, you want to have a good foundation under that mansion or house to support the walls and the roof and all of that. So think of selecting your business entity and setting it up correctly as building the foundation on which you then add value to your business. So if we go to the next slide. This is a list of some of the common business entities that you see over time. Sole proprietorship, general partnership, limited partnership. You don't see that very often. Only limited situations. S corporation, C corporation, limited liability company, low profit limited liability company, and not-for-profit corporation. Each of them has a little bit of a different setting where it's appropriate and different situation where they can be used. Next slide. If we were in person, I would ask Liz to kind of sit down with you and provide a general overview of the matters there. And so I will do that at this juncture. But I guess I won't. Liz, could you please do that?
Alan? Let's see. There are a lot of factors to consider when you're setting up an appropriate business entity. You start by looking at the type of liability, tax implications, how complex you want it to be, or what you can handle, the kind of capital that you're going to be looking at, and the credibility that it shows in the business world that you'll be working in. Essentially, there are two kind of primary paths that people go down, and one is corporation, and the other is LLC. LLC is short for limited liability company, and you hear kind of a lot about those when you're kind of in the business world. They are structured differently and have different tax implications and different kind of management structures. And we will touch a little bit more on that. So here we have a little bit more about how each is structured. For corporations, the owners are referred to, you have stock in a corporation, and the owners are shareholders or stockholders. Excuse me, typically, and if you form in Illinois, they are referred to as shareholders. If you form in Delaware, they're referred to as stockholders. So same thing, just different terminology. Similarly, for a limited liability company, the owners are called members. In corporations, the owners get stock in the corporation, and in a limited liability company, you get membership units. The people who make the kind of big picture and major decisions for a corporation, that responsibility lies with the board of directors. They govern how the corporation is run. And so essentially the officers report to the board, and the board tells the officers what to do and how to do it. And the equivalent to that in a limited liability company are the managers. There is also an option to have a member managed limited liability company. And when you have a member managed limited liability company, the members act the same as if they were managers. For the day-to-day operations and who has authority to do things, when you're thinking about a corporation, that lies with the officers. So in a corporate entity, there's a president, a vice president, secretary, treasurer, and the kind of the equivalent for the limited liability company. Sometimes limited liability companies have officers. You have the ability to elect officers. Sometimes in the general public, that makes more sense from the forward-facing standpoint. And also the managers or members can also make day-to-day decisions. So if you have a limited liability company, you might, sign an agreement as the manager, and that would be kind of as an officer type of role. Okay, sole proprietorships. These are, we in our practice don't do a whole lot of sole proprietorships. This is kind of, if you're, sole proprietorship, if you're a single, if it's a one person business, and I can't even, it's been a while since we've started one, so I'm not even sure, what to give some examples of what one would be, but you just start it on your own and have some different kinds of protections. General partnership is similar, and you file a partnership tax return, but you have more than one person involved. We rarely do we recommend, actually I can't think of a time that we have recommended a general partnership, but we tend to point people more towards limited liability companies. Limited partnership, these are structured, mostly we see these when, like, as an investment tool, or when there is multiple partners looking at forming a business. In our practice, again, we see these mostly in like a private equity firm. Up next is S corporations. These were, a few years back, this was quite frequently what most businesses were starting as, and we did a lot of these. There's limited liability for the shareholders. It has a pass-through tax treatment, and the formation is very similar to what we'll talk about for a C Corp, where you file articles of incorporation with the state. The next step with an S Corp is that you file a sub S election with the IRS. And so that is telling them that you want to be taxed as an S corporation. Again, tax laws have changed over the years. And while this was what we did most often a few years back, because of changes in tax law, we don't do them as often anymore.
Thank you, Liz. I appreciate you filling in for me for a bit. You did a great job. I may hold on. I may bounce things back to you. We'll kind of do a tag team here. I don't teach school every day, and so sometimes if I try to speak for 50 minutes, I think you guys will get tired of listening to me, and it's kind of nice to have a tag team going here. The C Corporation historically was, the backbone of a lot of companies. It provides for limited liability, just like the S Corporation and LLC, but it incurs a double level of taxation. So for a lot of small businesses, they prefer to avoid that. I do see C corporations a lot, though, when we set up companies that are seeking to commercialize technology. So my office is in the U of I Research Park, and we work with a lot of companies that are trying to bring new technologies to the marketplace. Sometimes they try to attract outside funding, such as from angel investors and venture capital firms. And the C Corporation is the preferred entity to do that, to accomplish that. As well, for a larger organization, if you're going to have a lot of shareholders or owners, it's best to have a lot of times you prefer to avoid the pass-through tax treatment, because every owner is going to get a K1 in an S corporation. And a C corporation, you don't get a K1, which means you don't have to deal with pass-through tax treatment that you have to report on your personal income tax return. Another aspect of the C corporation is that it provides the ability to have different classes of stock. Subchapter S corporation, everybody has to have the same type of stock, but you can't have both voting and non-voting stock in a sub S. In a C corporation, you can have special preferences. So if you have the founder who started the company, and then the founder wants to take on investment, and the investor wants stock that has additional privileges, such as the ability to get their money back out in the event of a sale, then that preference can be accommodated through the C corporation. We set up a lot of C corps in the state of Delaware if venture capital is going to be funded or sought. Next up is limited liability company. These entities came into being not long after I started practicing law, so I've been around a couple of years. And they have increased in popularity over the years because they can be relatively simple to start up, form, and they can be set up in a way where you don't have to pay regular wages to the owner. They get an owner's draw. And so sometimes you can avoid some of the formalities associated with paying payroll taxes if you don't have other employees. Payroll taxes and the filings that go along with that can be sort of a headache to a smaller business. And so oftentimes for a very small business or a business that is perhaps a side business to the owner's main occupation, a limited liability company is a good choice. The other situation is oftentimes for ownership of real estate. It's almost never a good idea to own real estate in a C corp. There are adverse tax consequences to taking the real estate out of the C corporation. And so the LLC provides that flexibility to, if you want to sell, there's not a taxable event in and of itself to take the LLC out of, or the real estate out of the limited liability company. So for a larger entity that's going to, say, build a factory, you might have a C corporation that would own the main business, and the real estate would be owned by a limited liability company, and there would be a lease between the two. Commercial real estate is often held as or rental real estate is often held in an LLC. A lot of the apartments around town, if it's a large apartment building, they'll have one LLC per apartment building. If you have a number of smaller, say, houses, 2 or 3 smaller houses, you might form one limited liability company and have it own all 3 of your rental homes. Next slide. The single member limited liability company is sort of a nice choice sometimes. It provides the ability to have sort of the limited liability associated with a corporate entity, but not having to file a separate income tax return. And so it gives you sort of the best of both worlds if there's only one owner. So if, for example, you are going to, you have a main job, but you're going to do a little bit of consulting on the side, and you want a limited liability entity to operate that, this is a good choice. We set up a lot of these for professors who do consulting on the side, where they're not trying to commercialize technology. They're just trying to earn a little bit of money consulting in industry, and they want some liability protection to be associated with that. And also, if you have a single member limited liability company, you typically get an EIN for that. And so you don't have to hand out your social security number associated with the business. So next slide. For an LLC, one owner LLC, we typically have an LLC operating agreement that helps creates a little bit of formality to show that and demonstrate that the LLC will stand behind the owner in the event the owner gets sued on account of something the LLC incurs from a liability perspective. There's some choices you can make for succession planning. For example, if you want your spouse to automatically be able to become the owner, there's some special language that you can add to the LLC formation documents that can create the ability to do that. Next slide. The multi-member LLC is a little bit more complex. When you're going into business together and you have more than one owner, you're entering into a relationship with these other owners. And so number one, you always want to make sure you're comfortable with other people you're going into business with, because it's kind of a family in some respects. And you need to be comfortable with this, doing business with these other people over the long term. That having been said, the family needs some sort of policies or ways that things are handled, and the LLC operating agreement typically spells that out. One of the things that I see most often ignored when people set up a limited liability company is they form an LLC by filing with Illinois Secretary of State, but they don't say who the members, they might say who the interested parties are, but they don't indicate whether they're members or managers. Those are different people, or can be the same, but they have different roles, and they don't say who owns how much. So you have 3 members. Is it all equal? Does one of you have 20% and the other 2 40%? That's the one thing that I oftentimes see ignored when people, or overlooked if people do it themselves. So make sure if you do handle that yourself, that you adopt a appropriate operating agreement and document who the members are and who the managers are, what their ownership percentages are, and so that you'd reduce the possibility of disputes later on. Next slide. This is a hybrid organization. So we have for-profit undertaking, and then we have not-for-profit undertakings, such as a church or the Boys and Girls Club, or even the Chamber of Commerce. A hybrid organization is a low-profit limited liability company. In general, if you form a not-for-profit, organization, or a for-profit organization, such as a C Corp, S Corp, or LLC, you have a fiduciary duty to make a profit for the other owners. In a low-profit limited liability company, you have an you don't have that obligation. There's an acknowledgement that there may be a social purpose to your organization. And so, for example, if you are taking a long shot with investor capital and you're seeking to develop some sort of green technology, but all the investors understand that an increased level of risk is being undertaken that you wouldn't normally take in a for-profit undertaking. And so they acknowledge that and they say, we're not, basically they're allowing you to take a lot more risk to try to accomplish that social good. However, if it is very successful and the entity makes a lot of money, then everybody still owns a portion of the limited liability company. So it sort of has a hybrid between a for-profit undertaking where there's a fiduciary duty to try to make a profit and a not-for-profit organization where it's for charitable or other specific purposes. I did see a question pass through, and I'm not catching all the chats, but it flashed across the screen. And the question was, why do I recommend Delaware as a state of formation for a company that would be seeking venture capital funding and is looking at forming a Delaware C corporation? So Liz, if you want to go back to that slide, basically a Delaware corporation is the established and recognized entity that venture capital firms prefer to invest in. All the investment documents are geared towards Delaware law. And the venture capital firms typically don't invest only in a particular state. You might get investment from California, from Iowa, from New York, from Massachusetts, or other places throughout the world. And so Delaware is the common language, so to speak, the common language of investment law. And so Delaware that's one reason. A second reason is sort of just tradition. Everybody expects it. A third reason is there's a well-established body of law. There are a lot of cases decided in Delaware because they got an early lead. And why does everybody go to that store? Because everybody goes to that store. So sort of, if you are on a real budget, say you're a student startup and you don't have a lot of money and you've got a couple of founders, but you want to establish these organizational documents. So as you're building your family, which is your owners, your business, you want to have legal relationships between the two of you. Sometimes we can save a little bit of money by forming it in the state of Illinois initially, and then switching it to Delaware later on. It's a pretty easy process to do that. And if you're on a very tight budget, sometimes that's a way to go. It avoids a little bit of filing fees up front, and then it avoids an extra annual report each year. If you do form the entity in Delaware, you still have to be authorized to do business in the state of Illinois if you have an office here or employees here. So there is some extra cost. So it sort of depends on your funding situation and how likely it is you are to move forward with venture capital investment and how soon that might occur. So, all right, if we could go back to kind of where we were, Liz. Okay, a little bit about nonprofit organizations. There are a variety of not-for-profit corporations. So you have not-for-profit corporations that they can be categorized different ways. They can be exempt from income tax, federal income tax. The state of Illinois income tax tracks federal. Sales tax exemption in the state of Illinois is a much more narrow exemption. And then you see property tax exemption. That only applies if you own real estate. Carl has had some very public battles, now mainly wound down with the city of Urbana over property tax exemption, for example. And the rules sort of evolve on there. So those are three different categories of tax exemption. You may have income tax exemption, but not the other two. There are also a variety of flavors of income tax exemption, which are really beyond the scope of this. But Liz, next slide. Here's some initial steps. You file articles of incorporation, elect officers and directors, adopt bylaws, and then you're a not-for-profit corporation, but you're not tax exempt yet. You have to apply to the Internal Revenue Service on IRS form 1023 or 1024. It's now an online portal in order to get 501c3 status, 501c status, and there are a variety of C statuses. Churches and Boys and Girls Club and things of that nature would be a C3. A Chamber of Commerce would typically be a C6. So if you pay dues to the Chamber of Commerce, that would be a tax deduction for a business expense. But if you donate to the Chamber of Commerce, you don't get a tax deduction for that. Next slide. Here's a couple of, we've already mentioned these. So next. Let's repeat. Next. Oh, there was one item on the last slide that I'll mention. If you do form a charitable organization and you do any public solicitation of funds, you need to register with Illinois Attorney General. So that's an important thing that oftentimes people overlook. All right, so we'll kind of pause here and see if there are questions today. Let me see in the chat. Let's see some.
There was a question Alan submitted. It says, I have a member in my LLC who is also an investor. How should they pay taxes / show taxes on their investments?
Okay. All right. So the LLC is if there's more than one owner in a limited liability company, the default classification from an income tax perspective is that of a partnership. And that means that each partner will end up paying tax on the partner's proportionate share of income and expenses to the limited liability company. And that income and expense is calculated, transmitted to the each owner when the Form 1065 is filed. That's an IRS income tax form is filed. And there will be a K1 that goes along with that transmits information to the fact that that is an income tax item that individual is supposed to report on their income tax return. So filing the partnership tax return, generating the K1 is the way you get that information to each owner. Assuming that it has the LLC has the default partnership classification. As we'll mention in a couple of slides, there are situations where you elect to be taxed in a way different than the default partnership tax classifications, and we'll get to that. The nuances of partnership tax treatment, I'm very happy to leave to accountants. not my bailiwick, but except to say that it passes through, and when you file the income tax return for the LLC, it will generate a K1 that each owner gets. These are some steps to forming a limited liability company. We've got articles of organization. We file those with the Illinois Secretary of State. You can file that online. That's the area where people think, oh, we formed it, but did they form it correctly? Do we know who the members are? Do we know who the managers are? Do we know what ownership percentages each has? And that is typically not fully accomplished with articles of organization as filed online. Then the LLC would then apply for an EIN. That's something like a social security number for your business. Your social security number is for you, but it's like a social security number for your business. It's a tax ID number. Sometimes you will also file a Form 8832 and a 2553. Remember, we just spoke to the fact that the LLC by default has a partnership tax treatment. But you can tell the IRS, I want to be taxed as a subchapter S corporation. And that's the way you do it. And there's some limits on when you can do that and such and how you go about doing it. I don't typically recommend that. It's only in a very niche situation. Most of the time, you're just better off forming, if you want to be an S corp, just form a subchapter S corp. Don't form an LLC and then turn it into a S corp for tax treatment, because it creates a lot of confusion among bankers, other business people, accountants, owners, everybody. When you apply for a grant, it's not going to fit in either category squarely. But there are occasions, very, very limited occasions, where it might make sense. Or sometimes people change their mind after a period of time, and under certain circumstances, you can file these forms later on after you've already established the LLC. The next step is you typically do organizational minutes, where you provide elect and document who the owners are, how much of the LLC each person owns. You can either do that through percentage interest, saying it's a third, a third, a third. You can do it, or 60%, 20%, 20%. Or you can do it through naming a number of membership interests. One owner gets 500 membership interests, another one gets 200, and that's it. And then you would have to calculate the percentages. So you can do it either way. And then the key component is the difference between a manager managed LLC and a member managed LLC. I almost never form a member managed LLC, because even if you have, say, 2 members that you want to participate in management, sometimes you will make a decision to add a 3rd member who you don't want to have participate in management. Say you gift a few shares to a teenager or somebody who's 19, who is legally able to do that, to own the shares and such, but you don't want them to be able to sign or have legal authority to bind the limited liability company to a contract, for example. So almost always it's better to set it up as manager managed LLC. The operating agreement then kind of spells that out a little bit more detail. Sometimes the operating agreement provides quite a bit of flexibility. You can have different types of membership interests. You can have different types of, so you could have common and preferred. You could have founder membership interests that have certain preferences, or you could have investor membership interests that take precedent on some issues. Some membership interests may not have the right to vote. They may be non-voting. So there's quite a bit of flexibility in how you do that. So next slide. Let's see. This is sort of a checklist: management structure, ownership percentages, profit and loss sharing. There's some complex things related to inside and outside basis that only accountants love to talk about, but it kind of gets into those. Transfer of ownership is a big issue. If three people get together and form a business, you may want to be in business together, but you may not want one of the owners to be able to transfer their membership interest to a 3rd party. And so having some sort of control over how that is handled is an important issue. Record keeping and reporting, sometimes you spell that out. And it's a good idea to review it from time to time. There's a question in the chat about how husband and wife are treated for purposes of, I suppose, LLC membership interests. Say 10 years or so ago, you could have a husband and wife who own an LLC, and it would be a disregarded entity for income tax purposes. It'd be treated as a single member LLC. And so it was a husband and wife single member LLC. You can't do that anymore. The IRS clarified maybe 10 years ago that they don't allow that. What you can do is have one spouse be the owner and then have a payable on death clause that says that if that spouse dies, then the other one becomes the owner. But there's only one owner at the time. If you're seeking to be a one owner LLC, if you have a limited liability company that is a multi-owner or multi-member limited liability company, the husband and wife can have interests that are separate. Husband has 100, wife has 100 membership interests, or you could have them, wife and husband own all 200 membership interests as joint tenants, and the survivor, the ownership would pass automatically to the survivor of them. Next slide. This is getting into sort of the details of a fairly long LLC operating agreement that we oftentimes use in the state of Illinois. First section is formation, name, principal, place of business, registered agent, and office. That's something to talk about. A registered agent is where if the company gets sued, the company is a different legal being, sort of. It's not alive, but it's a different legal entity. Think of it almost as a being, as an entity. And if somebody needs to file a lawsuit against that entity, they will send paperwork to that registered agent or office. Sometimes that's an attorney. Sometimes one of the owners serves as the registered agent. Sometimes you find some third party to do it. Next slide. Sometimes you form an entity for a special purpose, but a lot of times you just put in a general purpose in the type of business that the LLC is undertaking. Next slide. Here's where you describe the ownership, the authorized units, the membership interests. Most of the time, the default classification is that everybody gets the same rights, but you can certainly have and draft operating agreements that provide for different types of rights for different types or classes of owners. Next slide. Managers, they're the people who sort of have authority to run the business. So if you have somebody who is the kind of business person and running things and signs contracts and such, that individual would be the manager, or you could have more than one manager. If you have somebody who owns only 5% of the company and you don't want them to be able to legally bind the company, then they should not be a manager. And this sort of describes some of the duties and things that managers do. Next slide. Officers are optional in a limited liability company, but some companies want to have a president. You can also come up with, president, vice president, secretary, treasurer are the historical offices that oftentimes people come up with, but others want to have a CFO or a CEO, chief executive officer, or vice president of product development, or vice president of new acquisitions, or all sorts of titles. And you can come up with those and spell those out in the LLC operating agreement if you so choose. Next slide. Next slide. If you want to have a meeting of your members and managers, that section would tell you how to do it. Next slide. Capital accounts, those are very important from an income tax perspective. And so the default operating agreements all are set up to be a partnership tax treatment. So 99 times out of 100, if you come across an LLC operating agreement, it's going to be for partnership tax treatment. And that talks about those nuances that accountants love to talk about it at social gatherings. And I mean that in a positive way. They're intricacies of the accounting process for a limited liability company taxed as a partnership. Next slide. And again, more accounting stuff. Next slide. Transferability, right of first refusal. Say one individual gets an offer Say the 60% owner, somebody comes in and says, I'll buy your 60% for $1 million. Most of the time, the other minority owners will say, hey, we want to sell ours too. You would want to, that would be the right to tag along on the sale. Don't leave me out of the sale. A right of first refusal would say that if somebody gets an offer or wants to sell their membership interest, the other parties have the right to buy it on the same terms and conditions. So next slide. How you admit new members. Next slide. And winding down. Next slide. And a lot of times we have membership interests or certificates that evidence the ownership of the LLC membership interests. Next slide. Indemnification is an important issue. One thing to think about is if you form a company that has any significant level of risk, having appropriate insurance for the company, including possibly officers and directors liability insurance. And this is a way to say that the business will stand behind an officer or director if they get sued, and they will make them financially whole, subject to certain conditions. Next slide. And miscellaneous. Next slide. I went through a lot of detail sort of on setting up an LLC. A lot of those similar but different issues are covered in 2 documents for a corporate entity. They would have bylaws and a shareholder or stockholder agreement. And so those 2 documents sort of combine the things that are addressed in a limited liability company, but they do it in a different fashion. We don't really have time to go through the nuances of that, but a lot of the same issues will be addressed, except not near as much on the tax perspective are typically contained in there. So next slide. If you are thinking about trying to use company ownership to motivate employees, you're probably going to want to have a C corporation. And there are ways to do that in a tax advantageous way. That's typically done for a tech company. Incentive stock options, non-qualified stock options, stock that vests over time. If you're setting up a tech company, there are a lot of issues that I haven't really addressed yet, but vesting schedules, making sure that you're setting it up to qualify for small business tax treatment from a Section 1202 income tax perspective, so that other investors will be attracted to it, all important issues. But if you're using the word, hey, we want to get some options to these people, you're probably, or ownership to some of your key hires early on, you're probably looking at a C Corp. Next slide. A lot of times things that are overlooked can be employment agreements. If it's a fairly simple, say you own some real estate and you have a maintenance person helping you maintain it, you may not need an employment agreement. But if you are commercializing technology, you want to have an employment agreement that addresses ownership of intellectual property. In the past, we always had a non-compete for that type of situation. Now there's a number of limits on how you can draft those non-competes. You want to make sure that in certain circumstances, an employee can't, if they leave, solicit customers or other employees, ownership of intellectual property, things of that nature. This topic isn't all about employment agreements, but it's something to think about if you form a company and hire employees, whether it's it's a good idea to have that, and if so, how to structure it. Next topic, next slide. Maintenance. Okay, you form the thing, you got to take care of it. And with an entity formed in the state of Illinois, you're going to have to file an annual report each year. If you are authorized to do business in other states, you have to file annual reports with the Illinois Secretary of State or with the Secretary of State of each state. At times you typically have to become authorized in other states if you have employees in other states, if you have to file sales tax returns in other states, or if you establish a physical office in another state. Those are sort of some of the low-hanging fruit. If you form the state of Delaware and you're going to have an office here in Champaign, Illinois, and be based in Champaign, Illinois, you're going to need to be authorized to do business in the state of Illinois. It's a good idea to do minutes each year, electing officers or directors, or members or managers or perhaps officers in the case of an LLC. There's also a whole bunch of tax compliance that that this firm doesn't get involved with, but you would want to consult an accountant with, including income tax filings for federal and state level, payroll taxes, sales tax returns, things of that nature. And then make sure you've got liability insurance that's appropriate for your situation. If you're doing consulting, you may want a consulting agreement. If you're getting big and you have outside investor money, you probably want officers and directors liability insurance. Next slide. If you don't follow the corporate formalities, the liability protection that an LLC or a corporate entity provides kind of goes away. It's a piercing of the corporate veil. If you don't use the name of the business correctly, if you don't sign contracts in the corporate name, if you commingle funds, if you don't respect the separate nature of your limited liability company, such as your LLC or corporate entity, then owners and officers can become personally liable, which is something you typically don't want to have. Next slide. So that kind of wraps up the slides. You know, again, selecting the business entity that you want to form is an important decision. Sometimes you can change the business entity once you've set it up, but a lot of times it's sort of like building a small house and then adding on. Sometimes if you build a small house and maybe don't put a foundation into that small house, and then you add on 3 or 4 times, and all of a sudden you have a 3,500 square foot house, which is a decent size, and you realize that you don't have a good foundation under part of it, that could be an awkward thing. So it's not that you can't add on, but you know, doing the understanding what foundation you need to start and then making additions in an intelligent way is a way to help avoid headaches from your perspective, minimize liability, optimize the chances that your business will be successful. And let's see if we've got something else in the chat.
No, it looks like we actually caught up on all the questions that were in here, but I do know we had a couple people jump on after we had already started. So if you have any questions, you can drop those in the chat box and we'll get them addressed. And as a reminder, this is going to be sent out to all of our attendees for today, the recording of it. So feel free to join us for a future session with Alan. We have a session scheduled monthly between now and May. So you can learn more about the legal side of your business, way to structure things and things like that. So I do know that was a lot of information, but we'll hang here for a minute and see if we get any questions submitted.
Thank you, Jordan. Appreciate the opportunity to visit. And thank you, Liz, for filling in for a bit. It's an important issue, but forming an entity doesn't make your business successful. But not having the right entity and not forming it correctly and not maintaining it can be a big drag on your business. So.
We did get a question too, Alan. It says, are there advantages to having an LLC versus a corp if a single owner?
If there's only one owner, then there's a strategic issue. If it's a fairly small business and one owner, you may want to do the single member limited liability company, which is shown on the far right. If we were doing this in person, this is almost all I would use because it kind of gives you an overview of everything or most of the things. And if the single member LLC is shown on the right, you file, with the Illinois Secretary of State, the Articles of Organization, and you can do an operating agreement, apply for an EIN, or you can't even use your own Social Security number. And then you have an entity that provides limited liability. So it's best to do an operating agreement, but you've kind of got it done there. And if you got $5,000 worth of consulting work you're doing, that's probably all you want. If you're going to be doing things that are big, a and you want to have, own a manufacturing facility, if you're going to, try to grow it into an entity that's going to attract outside capital, if you want to sort of have a distribution of profits, but also pay yourself a reasonable wage, then sometimes people would prefer to be taxed as a subchapter S corporation. But there is the obligation to calculate that reasonable wage at that point in time and pay, and then file payroll tax returns, which is an additional hassle. So if you make your main living at the university or some other job and you're doing some consulting on the side, you don't want to have to deal with payroll tax returns. You just want to report it on your personal income tax return. So again, kind of on the right-hand side are the issues, income tax, the tax implication, complexity of formation and management, effect on your ability to raise capital. That's the left side. Across the top, our choices are sole proprietorship, general partnership, S Corp, C Corp, LLC, and one owner limited liability company. We didn't mention, the not-for-profit organization here or the low-profit LLC, but and like Liz said, the limited partnership is really only for venture capital firms at this point in time. So, yeah. Did I see another question or?
Yeah, a question came in about getting assistance figuring out what structure their business should have. And I am gonna plug the SBDC here for a second, that our advisors can definitely help with that. And then if there's something that they can't do beyond that, they can always refer you over to Alan as well. We cannot give legal advice here in our office, but we can help you evaluate the pros and cons of what entity you want to form. And then, like I said, if there's something that we need to hand you off to Alan and Liz, we are certainly happy to do that as well.
Okay, and then the next question, can you help me figure out what structure an after-school program for a certain type of teens should be under? If it's a not-for-profit undertaking, it could be that it would be under the umbrage of an existing entity. So perhaps an existing entity would be willing to, for the first year or so, sort of sponsor you, so you don't have to do a bunch of paperwork. And then you've got the insurance in place, the entity in place, all the headaches in place to kind of get you up off the ground. And maybe they could serve as an incubator for you. Or perhaps it could be under the school district if the school is willing to go along with it. At a certain point in time, you may want to then sort of graduate and have an entity that is specifically for that program. And typically that would then be a not-for-profit organization, a 501c3 organization. When I was early in my practice of law, I was on the Don Moyer board of directors, sort of as a Muhammad rep. They had sort of a satellite facility in Muhammad, and it was owned and operated by the Don Moyer Boys and Girls Club. And then eventually it's like, time for you guys to graduate, And so they formed their own entity, and I helped do the formation documents for that. And then, additionally to that, we set up a private foundation that's designed to attract bigger gifts, right? But, sometimes if you're just getting started, kind of piggybacking or getting some coverage through an existing entity can help, or if you have a certain set of funds that somebody wants to donate to fund it, sometimes the community foundation can kind of host those and provide some of that structure for handling funds. There's a copy of this handout and other things on our website if you want. SBDC has a ton of amazing resources. Or if you have specific questions, I think the group here is pretty small, so, I could chat with somebody if they want to touch base, but yeah.
Thank you so much, Alan. So we are all caught up on questions and pushing 3 o'clock here, so we can go ahead and wrap up today's session. Thank you everyone for joining, and thank you, Alan, so much for presenting, and Liz for tag teaming. We really appreciate your guys' insight and knowledge shared with our clients.
Thank you, Jordan. Thank you, Liz.
All righty. Everybody have a great day, and we hope to see you next time. Bye-bye.